This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
I'm Spencer Mazyck, and joining us now from Washington, D.C. is Greg Stohr, Supreme Court reporter for Bloomberg News. Greg attended today's opening arguments over President Barack Obama's health care law. Today, the justices heard arguments on the question, does the penalty for failing to get insurance amount to a tax? Greg, what were some of the highlights from today's debate?
Spencer, several of the justices suggested they were prepared to go ahead and rule on the merits and conclude that the Anti-Injunction Act was not an obstacle. The central question there is whether these penalties that you have to pay under the health care law for not having insurance, whether that's a tax. And if that's a tax, the Anti-Injunction Act may apply, and it may be that you can't sue until you actually have to pay the tax in 2015. The gist of the question seemed to be that the justices were not inclined to say that the penalties are a tax.
Okay, and so were there many questions right out the gate for Robert Long, who, of course, is the attorney arguing that the court should not decide this case now?
There were a fair number of questions. At various points, 8 of the 9 justices took part, everyone except for Justice Thomas, who traditionally doesn't ask a lot of questions. And all 8 of them, if I'm counting correctly, did ask questions of Bob Long. And the most skeptical ones seem to come from the court's more liberal wing, the 4 Democratic appointees.
Is that surprising at all?
In the world of the Anti-Injunction Act, it's hard to be surprised because this court hasn't directly confronted it in several decades, not since nobody on this court has ever directly confronted the statute. So it's sort of hard going in to think you know what somebody thinks about the Anti-Injunction Act. That said, the court did rule on a somewhat similar statute a few years ago, and it was the court's conservatives who were the most rigid in applying the Anti-Injunction Act. So just based on that, it shouldn't be too surprising that it was the more liberal wing that was quicker to see if they could find a way around the Anti-Injunction Act.
So, Greg, did most of the questions seem to center on whether the penalty for failure to comply with the individual mandate is a source of revenue?
There were certainly some of those questions. Justice Ruth Bader Ginsburg, Justice Stephen Breyer both hit on that point. There's also a point that will be probably not dispositive in the healthcare case, but of interest to tax lawyers about whether the Anti-Injunction Act is jurisdictional, meaning that the federal government can't waive it, that the court just can't hear arguments, or whether it's non-jurisdictional. Again, that's probably not something that ultimately will determine how the case comes out, but it may be of great practical importance going forward in administering the tax laws. Okay,
and so were the justices at all bothered by the fact that Congress did not use the word tax to describe the penalty here?
There was Justice Stephen Breyer did raise that point a couple times. So there was some concern about that. That's certainly an argument for the Anti-Injunction Act not applying in this case.
Well, and I also wonder whether or not they made it a point to say, if they decide this case now, there would probably not be any interference with the collection of tax whatsoever.
That point did come up as well. Again, it was the more liberal justices who tended to bring that up. So that is certainly what you could ultimately see in an opinion for the court.
Well, and we should mention, though, that the Obama administration here, they're in agreement with the challengers on this particular issue, correct?
They are in terms of the bottom line. They get there through a slightly different means. They actually make the argument that the Anti-Injunction Act is jurisdictional, but that nonetheless it doesn't apply in this case, and they do that sort of based on the analysis of the healthcare statute and the fact that it doesn't mention the word tax, that sort of thing.
Is the government actually arguing, is there a difference between what they're arguing today and what they'll be arguing tomorrow?
There is some tension there, and it was tension that was brought out by Justice Samuel Alito. Right now, the government is saying for the purposes of the Anti-Injunction Act, these penalties are not a tax. Tomorrow, the government is going to be arguing that for the purposes of congressional authority, that one of the ways Congress has authority to do this is through its taxing power. And there they say you look at instead of the label that Congress used, you look at the way a provision functions, and they say that the provision functions as a tax.
Okay, and did you get a preview from the court of what some of the questions to come might be tomorrow?
Not on the big question of whether Congress has Commerce Clause authority. There weren't any questions that directly or probably even indirectly got to that. There was some discussion, as I said, of the taxing power authority, but certainly not enough that anyone could have left the courtroom today thinking they had much more of a handle on what the court's going to think tomorrow. Okay,
so Robert Long, you think unpersuasive in his arguments here today?
He had certainly seemed as though he had an uphill fight. There were relatively, oftentimes you get the best sense when the lawyers for the other side get up, and in this case the government and the National Federation of Independent Business. The court did not press either of them did not use some of the points that Bob Long had made to press either of them. In particular, the justices did not spend a whole lot of time making the case that this actually is a tax, which is what you might have expected if they were going to ultimately side with Bob Long.
Right. So I guess then, in sum, you think that the Anti-Injunction Act the court's going to say, okay, this doesn't prevent us from deciding the constitutionality of the individual mandate of Obamacare.
Based on the questions, that seemed to be the direction the court was going. There wasn't. It's not one of these cases where you could come out of the courtroom and count to five and say those five justices are definitely going to say the Anti-Injunction Act doesn't apply. But the overall tone of the questioning certainly suggested that was the way at least a plurality of the justices are leaning.
All right, that's Greg Stohr of Bloomberg News. For more information on this or other topics, subscribe to BloombergLaw.com, and you can follow us on Twitter. Thank you for joining us. Bye, everybody.
Copyright 2012 Bloomberg Finance LP. All rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take any responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.